Good evening. Thank you so much for joining us here on KTN Friday Briefing. My name is Betty Okari, and I'm very glad that you joined us on this 12th day of February 2016. Now we have a packed show. I'm telling you, we have the latest, of course, coming in from the ICC. We also have Willis, the word master, but very interestingly, my guest anchor tonight, I'm telling you, he's on fire. I'm going to be telling you a little bit about him shortly, but also what to expect in this bulletin is we will be talking to the newly elected president of the Football of Kenya Federation, Nick Mwendwa. He's going to be joining me shortly. Do text in, tweet me the questions that you have for him, hashtag Friday Briefing, and the number also to text in is 22155. So let me go back to my guest anchor. I want to show you two pictures of how he was before. I don't know if he's going to like me for this, but anyway, and then you'll see him now. He's a very popular guy. Let's take the two pictures. There we go. I don't know what he was eating back then. I mean, I think he should tell us. There he goes. He was quite bulky, probably weighing about 100 and... Whoa, look at that. Okay, I don't know. 100 and too many kgs. There we go. So he is my guest anchor. Let me bring him on so that you can see the transformation. I'm telling you. Mvita Member of Parliament, Abdul Swamad Nasir. It's great to see you.
Thank you. How are you?
You look really sharp.
Thank you.
I mean, just say hi to our viewers.
How are you guys doing?
Here you don't wave. You say good evening, you know.
Etiquette. Good evening. Good evening. This is KTN.
This is KTN. It's great to see you.
Thank you. Nice
What
seeing you as well.
happened? Okay, what were you eating back then?
I think a lot of good things, but I ended up eating better things.
So you feel great right now?
I feel excellent.
Right.
I feel excellent.
So people, your people, Vita people, oh yeah. So do text in any questions that you have. Tweet me also any questions that you have directed to the Mvita Member of Parliament, Swamad, as his friends like to call him. He's going to be talking to us, of course, on issues from Mvita, but also he's going to be telling us how he just lost all that weight. That and so much more coming up shortly. Let's have the highlights.
It's victory for Ruto on the use of recanted evidence before the ICC.
That rule would not apply in its case, but would apply in future cases.
And the implications of the ruling on Ruto and Sang's case at The Hague.
Victim of crime, whether it is theft or injury.
Kwekwe's family now asks for compensation as the sentencing of the culprits is postponed. And the primary school in Budalang is struggling to catch up with the rest.
Well, we have that and so much more coming up in the next 1.5 hours. Our sign language interpreter is William Silla. Now we begin this live broadcast with news from The Hague, where the International Criminal Court Appeals Chamber has earlier this evening ruled in favor of Deputy President William Ruto and his co-accused Joshua Arap Sang. The ICC judges have ruled to strike out the use of recanted evidence in the crimes against humanity case facing the two. Samogina has the details.
The appeals court decision has dealt a blow to the ICC prosecution's case. ICC prosecutor, in applying for the use of recanted evidence, admitted that without the recanted evidence from some 5 witnesses, her case would be weak. Bensouda had also complained that her witnesses had been intimidated to withdraw from the case. But the appeals court has overruled the trial chamber, stating that the application of Rule 68 was detrimental to Ruto and Sang.
The appeals chamber finds that the application of this rule affected negatively the overall position of Mr. Sang and Mr. Ruto in the proceedings in hand. Accordingly, the appeals chamber holds that the trial chamber applied amended Rule 68 of the rules retroactively to the detriment of the accused.
While the prosecution goes back to the drawing board, it is a big win for the defense teams of Ruto and Sang. In reversing the trial chamber decision, the appeals court stated legal errors were committed in admitting the use of Rule 68. The court saying the admission led to the restrictions of the defense teams from cross-examining witnesses, a cardinal principle in judicial matters.
The appeals chamber notes that some witness testified in court and recanted the content of their prior recorded testimony. In these circumstances, even if the accused had an opportunity to question the witness because they appeared before the court, the appeals chamber considers that in the absence of the prosecutor eliciting incriminating evidence from the witness in examination in chief, such questioning does not amount to a meaningful cross-examination.
The court further found that Rule 68 was applied retroactively as it was admitted after the start of the Ruto Sang trial case. The Friday ruling appearing to vindicate the charm offensive by the Kenyan delegation at the Assembly of State Parties.
The appeals chamber decided to reverse the impugned decision to the extent that prior recorded testimony was admitted under amended Rule 68 of the rules for the true of its contents.
Focus now shifts back to the trial chamber, where the deputy president and the former broadcaster have filed a no case to answer motion. Samogina, KTN News.
Now, the decision by the ICC Appeals Chamber not to allow the use of recanted evidence is a major boost for Deputy President William Ruto and radio journalist Joshua Arap Sang, but a big blow to ICC prosecutor Fatou Bensouda. The ruling could significantly weaken Bensouda's efforts to secure a conviction against Ruto and Sang. Rita Tinina looks at the contentious Rule 68 of the Rome Statute and what today's landmark ruling means for the prosecution and the defense.
It was the Assembly of State Parties session in November 2013 that set the stage for what would turn out to be one of the most controversial amendments to the International Criminal Court Rules of Procedure and Evidence. Kenya, which was at the time pushing its own amendment to allow trial in absentia of President Uhuru Kenyatta, whose case has since been terminated, and Deputy President William Ruto supported the amendment of Rule 68 to allow use of recanted evidence in exchange for support on amendment of Rule 134, excusing accused persons from being physically in court. Kenya successfully pushed through its trial in absentia amendment, but her support for the use of recanted evidence would return to haunt Deputy President William Ruto.
I think what Kenya believed was that that rule would not apply in its case, but would apply in future cases. Of course, that is a known doctrine or a known procedure that any time a rule starts to operate, it operates from when it is enacted or promulgated rather than retrospectively.
In April 2015, International Criminal Court prosecutor Fatou Bensouda applied for the admission of prior recorded testimony, arguing that there was interference with prosecution witnesses, some of whom had been forced to recant their evidence. Bensouda won round one of the recanted evidence battle when in August 2015, Trial Chamber 5 allowed her to use primary testimony of 5 witnesses who had recanted their evidence.
Persecution with the intent to...
Deputy President William Ruto and his co-accused radio journalist Joshua Arap Sang challenged the decision. 5 months later, the controversy over recanted evidence has been put to rest with the victory for Ruto and Sang after the appeals chamber ruled in their favor. The ruling deals a big blow to the prosecution, which was relying on the recanted evidence to tighten its case against Ruto and Sang.
The court finding in this particular case that Bensouda cannot use recanted evidence simply means that the legal team plus the accused persons have lesser burden, lesser evidence, lesser weight of evidence against them to plow through. So it means that they can concentrate their defense on the little known evidence rather than on this other evidence that they truly believed had already been recanted and therefore would not be available in this particular case.
Bensouda may have lost some evidence crucial to her case and which might have been an asset, effectively weakening the prosecution's case and making it difficult for the ICC prosecutor to secure a conviction against Ruto and Sang. The Chamber's decision comes as Ruto and Sang await a ruling on their no case to answer motion, seeking to have the charges against them terminated.
This ruling, in terms of finding that their recanted evidence cannot be used, emboldens them. It makes them feel that actually the no case to answer is more weighty and can make them hopeful that actually the courts may find that on the basis of the evidence that's available, perhaps a further prosecution is a waste of time.
And just like their victory over the use of recanted evidence, the duo who traveled to The Hague last month for the hearing of their no case to answer motion will be hoping that the court will once again rule in their favor and let them off the hook. Rita Tinina, KTN News.
Right, and the developments of the ICC lead us to our big question tonight, and we'd like to hear your comments on what took place, but also if the ICC prosecutor should now kind of like give up on the Ruto Sang case. Should the ICC prosecutor Fatou Bensouda give up on the Ruto Sang case now that recanted evidence cannot be used in that particular court? Text us. The number to text in is 22155, and the hashtag to use is Friday Briefing. We'll be glad to sample your views in the bulletin. Now, former Kinango DCIO Veronica Gitahi and former police constable Isam Zeh, accused of killing 14-year-old Kwekwe Mwandaze in Kuala, will spend 2 more days in custody before they are sentenced. High Court Judge Martin Moya postponed the judgment pending scrutiny of mitigation presented before him.
Lawyer Haron Dubi representing Kwekwe's family cited the Victims Protection Act 2014 that allows those aggrieved to seek compensation, something that will throw in a fresh twist into the case and perhaps the reason why the court postponed the sentencing of the duo.
There are 2 main issues for determination by this court. The first one is that of arrest of judgment.
The family had to apply to court for exhumation of her body so that a second postmortem is conducted, which also they incurred expenses. Indeed, after that second postmortem, the report showed that the previous postmortem was false.
Tension was palpable in the courtroom as friends and relatives of the two gathered to listen to the final determination. Defense lawyer Jared Magelo led the defense mitigation as he pressed for a pardon.
What you say?
According to Ndubi, there was a string of attempts by the state to cripple the case initially, and it was time for the family to get real justice.
They wanted to give credence to the theory, the funny story. The Inspector General of Police, Mr. Kimayo, then, and the County Commissioner for Kuala, my friend Mr. Choki, had tried to paint that the girl had sought to attack the police with a panga, and in fact they said that she had even tried to cut their gun.
Francis Ontomwa, KTN News.
Embattled Supreme Court Judge Philip Tunoy wants Court of Appeal Judge GBM Karaoke, who is presiding the judge in the case in which he is challenging the retirement age for judges, disqualify himself from the case. Justice Tunoy told the 7-judge bench hearing the case that he, in the past, presided over a case in which Justice GBM Karaoke was fined $500,000 shillings for contempt of court while practicing as a lawyer, and that this could interfere with a fair hearing. The application will be heard on Monday, and Patrick Arimo has the details.
Court of Appeal Judge Justice GBM Kariuki led 6 other appellate judges on the first day of hearing a constitutional case challenging the retirement age for judges appointed before the current constitution came into effect. Supreme Court judges Philip Tunoy and Kalpana Rawal, who doubles up as Deputy Chief Justice, and High Court Judge David Onyanja filed the application to be retired at 74 years, as was the norm under the old constitution. But before the hearing could start, Justice Tunoy threw spanners in the works. Through lawyers Fred Ngatia and Firoz Noroji, Tunoy wants presiding judge Justice GBM Kariuki removed from the bench. Tunoy says in 1994, he presided over a case in which Justice Kariuki was fined $500,000 shillings for contempt of court. In 1994, while working as a human rights activist and lawyer, the ruling Kanu government brought criminal charges against Justice GBM Kariuki, the then People Weekly newspaper editor-in-chief Bedan Mugwa, and reporter David Makali. This was after Makali in the People Weekly issue of March 6 to 12, 1994, wrote an article where Kariuki was quoted saying a recent Court of Appeal decision amounted to, quote, judicial lynching and blackmail tailored to meet the political expedience of the executive, end of quote. This was after a 5-judge bench of the Court of Appeal dismissed an application by university lecturers perceived to be anti-government, seeking to block the university administration from evicting them from university houses. A 3-judge bench comprising 2 judges from the 5-judge bench, whose ruling was criticized, fined Justice Kariuki $500,000 shillings or serve 6-month sentence. Bedan Bugwa was fined 400,000 shillings or serve 4 months jail, while Makali was fined 300,000 shillings or serve 4 months jail. The hefty fines by then standards were to be paid within 3 days. Journalists Bedan Bugo and David Makali refused to pay fine and were jailed. Justice Kariuki paid the fine. Justice Tunoi is apprehensive. Justice Kariuki might now demand his pound of flesh.
I'm not looking forward to a contest. I'm looking forward to whether, in this modern world, it will be correct for a judge in that situation to hear a matter involving now the first appellant.
The first appellant knew, as at the 13th of January, that the presiding judge here was the judge presiding. No objection was taken to the Honorable Justice GBM Kariuki, Judge of Appeal, being part of the bench.
2 weeks ago, Justice David Onyanja wrote a letter to the Chief Justice Dr. Willy Mutunga saying he intended to proceed on terminal leave pending his retirement at the end of this month.
He actually has authorized me to say he intends to prosecute this appeal to the end. And he made that position abundantly clear in his letter which he forwarded to the head of the judiciary.
And I'm not sure whether he appreciates the distinction between resigning and retiring. I think it's good for you to take instructions and be clear whether he retired or he resigned.
The Court of Appeal judges will rule next week on whether Justice GBM Kariuki will be excluded from the hearings or not.
The first appellant's application shall be heard on Monday, 15th February 2016 at 2:30 p.m. Further orders on the hearing of this appeal shall await the outcome of the said application.
The conclusion of this petition on retirement age at the Court of Appeal is a matter that is awaited with keen public interest because it will determine the composition of the Supreme Court. Patrick Amimo, KTN News, Nairobi.